go on the record in People versus Michael Haley. This is file number 256876. The record should reflect Mr. Haley's present in the courtroom today due to Mr. Haley's mobility limitations. I'm just going to have you stay right there at the chair, Mr. Haley, as opposed to the podium. If I could have both counsel put your appearances on.
Good afternoon, Your Honor. For the record, Mike Roll on behalf of the people.
Thank you, Your Honor. Larry Brown on behalf of Mr. Haley.
This is the date and time set for sentencing in this matter. Mr. Haley, did you have a chance to go through the pre-sentence report and talk to Mr. Brown?
Yes, Your Honor.
Right. And Mr. Brown, just so that you're aware, the court is in receipt of a victim impact statement. I don't know if you and your client.
Copies were provided to defense counsel and probation is going on.
Okay.
I did receive a copy of Mr. Haley.
Mr. Brown, do you have any additions, deletions, or corrections to the report?
I do not, Your Honor. No challenges to the score.
Thank you. Mr. Rolla, did the people have any additions, deletions, or corrections?
Just a correction that the PSI indicated there was no victim's impact statement. And that's not the fault of probation report. It wasn't prepared until apparently February 23rd. But I would ask that it be made part and parcel of the PSI.
Okay. We will do that. Do you have any challenges to the scoring?
No, Your Honor. Thank you.
Do you have any victims that wish to address the court today?
No, Your Honor. That's why the victim's impact statement was sent. Our office was advised they were not coming up to the United States.
Anything on behalf of the people for allocation?
Briefly, Judge. Court was present during the defendant's trial where even the defendant's own son testified that he couldn't understand why his father, the defendant, then shot the victim, who his son described as a good man, and effectively allowed the defendant and his son to live in his home. Even when the son wasn't working for a time, 2 to 3 months, when he wasn't even charged for that. This generosity was returned by the defendant by effectively, unfortunately, killing him in cold blood. There's no sentence this court can impose that will effectively, truly give the victim's family justice. However, as our state and legislatures deem this offense which the defendant committed as a life offense, the court is limited in what it can do in regards to sentencing. Thank you.
Thank you. Mr. Brown, anything on behalf of Mr. Haley?
Your Honor, I will not belabor the points of the trial, as Your Honor was presiding over that trial. Mr. Haley is in very poor health. He is 71 years old. I understand the jury verdict. The court, I am certain by reading through the PSI, Mr. Haley still does not agree with that verdict. He is going to appeal, which is his absolute right to do. Any sentence, quite frankly, at his age, especially within the guidelines, Your Honor, is more than likely going to be a death sentence for him.
Thank you. Mr. Haley, is there anything you wanted to say today?
Yes, I have a statement I'd like read into the record, if I may.
Certainly.
Your Honor, I have a statement I wish to have read into the record. Unbeknownst to you, me, or Mr. Brown, approximately 7 to 3 days before my trial, and I'm going to say this probably came out of Mr. Rolla's office because it only could have, or one of his agents, through Facebook, TikTok, and the local media news, put his thumbs on the scale of justice by promoting and releasing several falsehoods. Number one, the trial, it's alleged that the trial took so long to be concluded because I tried to fire my attorney at the last minute to postpone the trial, thereby avoiding the justice system, and that I was laughing at the justice system. I'd like to point out that I never once asked for an adjournment. I was trying to replace Mr. Brown as my attorney starting in July. And I even voluntarily waived my rights to an arraignment to speed things up. The second point is I was thumbing my nose at the Otsego County court system and thought I was smarter than they are. That was reported on all 3 medias. It also stated that I only killed Russell DeLong in a failed attempt to stay in his residence on the property, which unfortunately that's laughable because number one, the property wasn't his, it wasn't even in his name. And number two, upon his death, I would have had absolutely no rights except rights as a long-term renter, and I would have had to have been evicted. It's just simply not true. Number three, it was further implicated. The summons for my son, which was one of the only two witnesses that wasn't an employee of the police department or the legal system as the medical examiner, etc. The only witness that the prosecution had was my son and one friend of Russ's. The summons to my son was sent to a residence that he hadn't lived at since high school. If he hadn't been looking for that summons to appear, he would have not even shown up. I really question how the summons got sent to a Grand Ledge, Michigan address that he hadn't lived at in well over 20 years. That's very strange. And then Mr. Rowles, I wish I could have a better word to put this, but I would term it shenanigans in losing the thumb drive during the trial and trying to blame it on the court reporter of statements made on the initial interview by my son to the police. I feel that influenced the jury. I don't feel that. I disagree with that whole process. I actually feel that Mr. Rowles should be found guilty of judicial misprudence with malice in the course of this trial. Now, I had been warned in advance by 3 different attorneys that worked with Mr. Rowles in the prosecutor's office that this was a common practice with Mr. Robbins. But I never thought that anybody would try to throw their thumb on the scale of justice in a matter like this, when I never once said that I didn't shoot Mr. DeLong. I never denied it, not once. I gave a voluntary statement to the police of the whole facts of the matter the night of the incident. I wasn't trying to duck responsibility. I wasn't trying to do anything except point out that I shot Mr. DeLong in fear for my life, and I never contemplated doing anything of the nature until he said that once I was dead, he was going to shoot my son in his head in his sleep. I have a minute, Your Honor. I fail to see how the jury pool could not have been contaminated, at least on a few of the jurors, with this media bliss just before the trial. I ask if you can recall personally, Your Honor, during a couple of court appointments in front of you, I pointed out that I thought I did not have a chance for a failed trial in this jurisdiction due to the lies and unfair news reporting in advance of the trial. And at the time, I had no knowledge of the news reporting and media that happened just before the trial. I mean, it can be understood to a degree, the initial news reporting. And And the facts that were reported as facts that absolutely were not factual. What I cannot understand is this last minute push just before the trial in 3 different venues to throw a scale, a thumb on the scale of justice. I do not understand. I don't think it was ethical. I don't think it was legal. And I think it needs to be addressed. And even though it probably will not affect the sentence that Your Honor gives me today. The facts are, Mr. Long kept a handgun in the arm of his chair. As a fact of course, there were guns stashed all over the house. Several guns. I pointed out to the police at the time of the incident that there were illegal full automatic weapon firearms in the house. They never did anything about it. No, I was never threatened with any of those illegal firearms. It was always with a pistol. But the cops never looked into that, ever. 3 days after the incident, the ex-brother-in-law of the deceased was allowed to come over and remove those weapons from the house. Another thing I disagree with was I repeatedly asked Mr. Brown to do an investigation and go take pictures of the entrance and egress on the house. Had I tried to leave the house before I shot him, the only way to get out of the house was to go past an armed individual that was in between me and the only exit that I was able to use due to my legs of the house. I would have had to go past a man that I honestly believed was armed. And he had previously showed me the weapon and put it back in the arm of the chair. I don't know where it went. I don't know if he had time when I went to my bedroom and back to pitch it, move it, or I have no idea. But I honestly thought that not only was my life in danger, when he said that he said, I'm going to kill you. And he said, and after that, I'm going to go shoot Dan in the head while he's asleep. His exact words were, I'm going to put a bullet in his ear. And that's what happened. But I couldn't have got past outside it. My exiting the building was just not going to happen. He said he would kill me if I left. I tried to get Mr. Brown to do an investigation, even to take pictures of the stairway. Unfortunately, there is 16 steps going from the ground up to an elevated deck. I call it the stairs from hell. It's a tough walk. To go out the back entrance, you would have had to jump off a deck with no stairs through a bed of brambles, raspberries, and blackberries to exit out the back, to go down through the basement and out the basement exit. I would have had to negotiate a circular stairway, go the full length of the basement, and then go through a woodshed to even reach the driveway. Exiting the house was just not an option, at least in my mind, and I don't think I was physically capable of it. My right to a speedy trial, I feel, was violated, and not by any doing by me. And it was reported in the news, TikTok, and Facebook that I was the one that slowed the trial down, and I was laughing at the Otsego County court system. I think my right to a fair trial was violated by the last minute rush in the news, TikTok, and Facebook. I fail to see how that could not have influenced at least one or more of the jurors. I just fail to see it. I thank you for your time and letting me read this statement, Your Honor. I never denied killing Mr. Long. But it was only in fear for my life, which I'll be absolutely honest. At my age and my condition, my life was not that important to me. But when Mr. Long said after he killed me, he was going to kill my son, that made my decision for me. And I make no apologies for it. This victim statement by the brother that I only now got aware of, I'd like to point out a couple things to your honor. Because I'm sure you're going to read the statement or you have. Jeffrey DeLong and Russ DeLong had not spoken to each other in almost 20 years. They hated each other. And one of the reasons that Russell DeLong was in danger of losing his home on the foreclosure in the state was Russell hid the property in his father's name to avoid an income tax lien, federal income tax lien. The brother, Jeffrey, knew about it. So at the time the father died, it was in the father's name and Jeffrey is the executor of the estate. There were 3 children to share in that estate, but the will was written up so that only the surviving children, at the time the will was probated, were eligible to be beneficiaries of the father's estate. The father spent 3 years, the last 3 years of his life, in an extended care facility, which upon his death, the home was adjudged to be part of the father's assets. So Russell's quote unquote home, which was never kept in his name to my knowledge, and I was paying the delinquent taxes on it. Not only that, I was paying rent for years, and my son was paying rent too. Mr. Rowell alleged that Mr. DeLong, the deceased Mr. DeLong, had even let my son off on paying rent while he was suffering from cellulitis and couldn't work.
So, Mr. Haley, I'm perfectly willing to hear what you have to say about your case as part of sentencing, but whether you agree with the victim's, his brother's statement or not, I mean, what does that have to do with anything?
Okay, I will just, all I wanted to say was, Jeffrey DeLong ended up, due to these circumstances, he ended up the sole beneficiary of the father's estate.
Okay.
And I'm going to quit talking about that.
I just don't understand what that has to do with the punishment that you should receive in this case.
Okay.
I mean, if you
to cut to the chase,
if you can tell me, yeah.
To cut to the chase, all I'm saying is this statement, and it's the way it's written is not entirely factual, and I won't say anything more about it, Your Honor. And I'm sorry to have drug it on so long.
Well, it's not that you're dragging it on; it's that
it has no import.
The victim's brother is entitled to feel however he feels, regardless of how good or bad their relationship. When you have somebody who's a family member who's killed, even if they're estranged and you don't like them, it can affect you. And so it's not that you're dragging things on, it's just what you're saying.
I can understand, Your Honor.
Yeah.
It all goes back to, the only point I was trying to make is this all goes back to the way that the deceased managed his affairs, and that's what I will just leave it at that, Your Honor, and apologize for misusing it.
Well, there's nothing to be sorry for. I suspect your attorney's giving you some good advice, which is
to shut up.
Well,
yes, sir. Yes.
Well, none of what you're doing is, to me, it sounds like you're saying, well, these are more reasons why it was okay for me to shoot and kill Mr. DeLong, because he didn't manage his affairs correctly and his brother really didn't like him and he was just a bad guy who didn't pay his taxes, and therefore I killed him. But, you know, it's not that big of a loss to anybody. I mean, that's what it sounds like to me. So I think your attorney
Sorry.
telling you to stop saying those things is
Sorry
probably
to
good.
interrupt you, hon.
Yeah. Okay, so yeah, I did listen to the trial. Obviously, I was here. I heard all of the evidence. I was part of all the pretrial proceedings, so I'm aware of everything that's happened from start to finish, at least once the case was found over to my court. I did read through the pre-sentence report, so I'm familiar with all the information in there. I did listen to what the attorneys had to say, and I listened very carefully to everything that you had to say, Mr. Haley, and I do want to address a couple of the things that you mentioned, not because it goes to the degree of punishment that you should receive for your crime, but because I think it calls into question the way that the court conducted the trial, and I think it's appropriate for me to respond to some of those things. Number one, and I pay very close attention, especially in trials where there's potential for publicity, because I want to make sure that the defendant and the prosecution get a fair jury and get jurors who don't come to the case with preconceived opinions about how it should be decided. I didn't see any kind of media blitz, as you indicated. I think there was one article on the local news that the trial was starting, but I didn't see any of the things that you're discussing, and I'm on Facebook and TikTok and those social media websites. So I don't know how accurate what you're saying is. I didn't see any of that. More importantly than that, though, is the first question that I asked every single prospective juror was whether they had heard anything about this case prior to the trial. And every single one of them said that they hadn't. So to the extent that there was any media coverage, not only did I not see it, but none of the jurors said that they saw it. So even if it happened, if none of them saw it, it didn't affect your trial in any way, because if they didn't see it, it can't affect it. And none of the jurors indicated that they had seen any kind of pretrial publicity or knew anything about the case. So the fact that there may have been media coverage on any of those platforms is really irrelevant. In terms of, Mr. Brown's representation, number one, I thought Mr. Brown did a good job during the trial of trying to raise the defenses that were available. I think when it comes to your claims of self-defense, what you're really not understanding or disagreeing with is the law. And the law on self-defense, as it was explained to the jury, and as it is in the state of Michigan, is threats aren't enough for you to use deadly force. You can't kill somebody preemptively because you think they might hurt you or they said they're going to hurt you. There's no evidence, or was no evidence presented at trial, none that I've ever seen, that Mr. DeLong presented a threat to you at the time that you shot him. He didn't have a gun. He didn't show a gun to you. He didn't point a gun at you. He couldn't have, because no gun was in his chair. So whether he's had possession of a pistol in that chair before or not, and whether you knew about it or not, the fact is, under the law, regardless of whether you think it's good or bad or agree with the law says that that person has to be presenting an imminent danger to you at the time. And him sitting in his chair and threatening to kill you is not enough for you to go get a gun and then shoot him at point blank range and try to justify it by self-defense. I mean, it's just, there's no evidence that would support a self-defense theory in this case. So the fact that Mr. Brown didn't go and take those pictures and didn't explain to the jury that you couldn't have gotten out of the house, none of that even matters, because based on the evidence that I saw at trial, none of it indicated that you were at a point then that your only options were to kill Mr. I'm not going to argue with you about it. I heard everything you had to say. I'm just telling you. So in my view, the things that you would have asked Mr. Brown to do, I think wouldn't have made any difference in the long run. I think there was overwhelming evidence of your guilt, overwhelming evidence that from a legal standpoint, you were not justified in using the force that you used at the time that you used it. The issue with regard to the summons to your son, I don't know what that has to do with anything to do with your guilt or innocence or a self-defense theory. The thumb drive, I mean, if anything, I think that would have hurt Mr. Rolla's case because it made him look bad in front of the jury, not you. So I don't know how that could have unfairly influenced the jury against you. And in terms of speedy trial and those types of things, those are all issues that you can raise on appeal. But I say all that to say that I think ultimately what you're just not getting, I think you thought in your own mind, he's threatening me. I'm tired of listening to his threats. I'm going to take care of it. And that's exactly what you did. I don't think you actually felt physically threatened, and you even alluded to it here today. You indicated that your life wasn't that important and you weren't that worried about it. You were more worried about your son. And certainly there was not an adequate basis here for you to use deadly force in defense of your son under the circumstances as they were at the time that you fired the weapon. So I think ultimately you decided that you were done listening to Mr. DeLong, you were tired of his threats, and you were going to end that, and that's exactly what you did. Later trying to claim that it was self-defense, but again, there was no evidence that there's a legal basis for self-defense here, and I think the things that you've tried to call into question with regard to the jury's verdict just don't hold water from a legal standpoint. So I think this was clearly a circumstance where you decided to take the law into your own hands. You decided to use deadly force when it wasn't justified. And there's really no excuse for you shooting Mr. DeLong at the time and in the way that you did. And so I do think that a lengthy prison sentence is justified by your actions in this case, regardless of your age or your current condition. The law demands that the court mete out the appropriate punishment. And in this case, the court is going to sentence you to 25 years to 50 years in the Michigan Department of Corrections. You do have credit for 265 days served. The court will order that you pay a crime victim's assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. You do have the ability to seek an appeal of this sentence, and so you'll be able to raise all the things that you've raised here with me today in front of the Court of Appeals. And if I'm wrong about any of that, then I'm wrong and we'll be back here. And if not, the sentence will stand, but you do have to file that appeal. And Mr. Brown, have you provided the appellate rights to?
I have, Your Honor, for the record, I did tender the acknowledgement.
Mr. Rolla, anything further on this file today?
Yes, Your Honor, in light of the comments I look at the record, I reserve doing this, so I don't want to be accused of in any way trying to impact the court's sentence. The defendant made certain aspersions against myself personally in my office. As this court's well aware, office has a very strict policy in regards to information being disclosed to the media. Until there's a trial, and until after there's a trial and there's a decision, our office only releases information that's already on the court record. In other words, information about the charging, the decisions, what potential penalties might be. But as far as any other information, we don't. And in regards to TikTok, I don't use it. I don't even allow it in my home because, again, I don't like the way that service works. And in regards to Facebook, if he's got postings that he's got something to show that someone from my office posted things on Facebook prior to the trial, I would like to see it because then I'll take appropriate action. I do know it wasn't me, so the allegations that he made, I felt compelled to address on the record. Thank you.
All right, thank you. That's all for this hearing today. Mr. Haley, you are remanded to the custody of the state. right, Mr. Steffi, if you would come forward with your client, please, to the podium. We'll go on the record in People versus Faith Dolar. This is file number 266954. If I could have counsel put your appearances on.
John, I called that people.
Good afternoon, Judge. John Steffi on behalf of the defendant. We're both here before you at our first status conference.
Okay. Mr. Steffi, can you tell me the status of this file today?
Thank you, Judge. We did run a prelim in this case. I'm waiting on the transcript to be prepared. So I was going to ask Your Honor for another status conference date. I would think at that point, we'll have a pretty good idea of if we're going to need a trial date or not.
Okay. Mr. Rolla?
As far as the length of trial, Judge?
No, I'm just, do you have an objection to an adjournment?
Oh, I'm sorry, Judge. No, Your Honor, I do not.
Okay. And Mr. Steffi, you said 30 days?
I think that should be good, yes.
I want to avoid coming back and then having to adjourn for another.
I as well.
days,
So maybe if we could do 45 minutes, that would be more prudent. My person I used to do transcripts does not work with this court anymore, so it's been a little bit of a hiccup, but we're figuring it out.
Okay, so we'll set it for a status conference, plea hearing in 45 days. So that would be the court's mid-April motion day. And if we don't have a plea at that time, then the court will schedule it, get it on the trial docket.
Great.
Mr. Steffi, anything further from your side?
No, thank you.
Mr. Rolla?
No, Your Honor, thank you.
Ms. Dolar, do you have any questions at all about how we're going to proceed with your case?
No, sir.
Okay, thank you. That's all for today.
Thanks, Judge. Have a great day.
Mr. Dick, do you have either of your clients ready?
Yes, Your Honor, Ms. Price.
Okay, we'll call People versus Carly Price, file number 256934 and 256946. The record should reflect Ms. Price is present here in the courtroom today. And Mr. Dick, can you tell me where things are at?
Yes, Your Honor. So today we were going to be entering a plea on both files. File that has possession of analogs.
So file number 256934, the charges are possession of analogs as habitual second, operating the suspended license as a second or subsequent.
Yes, thank you, Your Honor. On that matter, we would be entering a plea of guilty to possession of analogs in exchange for dismissal of the second count and all enhancements.
Mr. Roll, is that correct?
This was which file, Judge?
6934.
6934. Would be count one, possession of analogs, dismissal of count two, as well as the additional enhancements.
And the drug double enhancement as well.
Yes, Your Honor, all enhancements.
And then as to file 6946.
A plea of guilty will be entered to counts 1 and 3.
Correct.
Dismissal of the remaining counts and any.
And all enhancements, additional four.
Okay. Okay, Ms. Price, have you had an adequate opportunity to speak with your attorney about this agreement?
Yes, sir.
All right, and what you've discussed with him is that the same as what we've discussed here today?
Yes, sir.
Is that how you wanted to proceed?
Yes, Your Honor.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Price, are you currently on any kind of probation or parole?
No.
All right, and you understand that by pleading guilty to possession of analogs, in this case, amphetamines, that the maximum penalty you could face would be up to 2 years and or a $2,000 fine?
Yes, sir.
And that the maximum possible penalty for delivery or manufacture of methamphetamine is up to 20 years and or a $25,000 fine?
Yes, sir.
And using a computer or the internet to commit a crime carries with it a maximum penalty of up to 2 years and or a $5,000 fine. You understand that?
Yes, sir.
Mr. Dick, are you aware of any discretionary or mandatory consecutive sentencing sanctions in this case?
The only ones that are discretionary would be the ones with the methamphetamine and using a computer, I believe.
Okay, was Ms. Price on bond went during those, or is that the basis for the discretionary consecutive?
No, no, Your Honor.
So Ms. Price, with all of those penalties that I've just indicated to you in mind, what is your plea to each of those charges today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. Do you understand all those rights?
Yes, Your Honor.
And you understand that you're going to be giving up and waiving all of those rights by pleading guilty, and you won't have them anymore.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask the Court of Appeals to hear your case. They could say no, and that would be the end of any appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we said here in court today?
No.
Is it your own free choice to enter this plea?
Yes, it is.
Are you pleading guilty to these crimes because you are actually guilty of each of these crimes?
Yes.
So looking at file 6934 first, this indicates that happened around July 20th of 2025. Is that the correct time frame?
Yes, Your Honor.
At that time, were you present in Otsego County?
Yes, Your Honor.
Did you have possession of some amphetamines at that time?
Yes.
Did you know that that's what those substances were?
Yes, I did.
Did you have any legal right to have possession of any of those?
No.
And then the other case, the date I have on that is July 7th of 2025. Is that the correct date?
Yes.
And were you also in Otsego County at that time?
Yes, I was.
Did you have possession of some methamphetamine at that time?
Yes, I did.
Did you give or sell that substance to another person?
Yes.
Did you have any legal right to do that?
No.
And did you use a computer or the internet to communicate with another individual for the purpose of selling that or delivering that substance?
I did.
And that also occurred here in Otsego County?
Yes.
Mr. Rolla, are the people satisfied with the factual basis as to all three charges?
Yes, Your Honor, thank you.
Mr. Dick?
Yes, Your Honor.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
My people, thank you.
Thank you, Your Honor.
Are you both counsel, are you both satisfied that this court has complied with statute and court rule in the taking of this plea?
Yes, Judge.
Yes, Your Honor.
Ms. Price, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to all three. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. You're going to meet with Ms. Davis before you leave here today to set up a time for a pre-sentence interview. And then you'll have an opportunity to go through that report with your attorney prior to the sentencing hearing. Mr. Rolla, anything further on these files today?
Not in this matter, no, Judge. Thank you.
Mr. Dick?
No, Your Honor.
Ms. Price, do you have any questions about how we're going to go forward?
No, Your Honor.
Okay, thank you. That's all for today. And Mr. Dick, have you had any contact with Mr. Robbins?
He is currently in the Roscommon County Jail.
That's where. Written there.
I was looking, I don't see them right offhand, but let me look in my email from,
We'll call People versus Robbins, file number 266956. Counselor present, Mr. Robbins is not. This hearing was set for 2 o'clock. It's now to 11. I do believe. Doc, it does indicate that he might be still lodged in Roscommon. Do you know if that's the case for
It
sure?
is.
It is, okay.
Yes.
Kyle Robbins.
I don't see a writ prepared, so I think.
I don't
we'll-
think my office was notified that he was there. I think that was. the
I
problem.
I do have an email from Misty.
Oh, wait, Roscommon's connecting.
Okay,
Ah, there you go. All right. I didn't see it written up on it.
All right, sir, are you Kyle Robbins?
Yes.
All right. Again, we're on the record in People versus Robbins. The record should reflect Mr. Robbins is now present from Roscommon County Jail by video. Mr. Dick, can you tell me the status of this file here today?
Yes, Your Honor. So I received notice that the prosecutor's office was sending out the remaining piece of discovery by mail. Yesterday, pardon me. So I would ask for an adjournment so that I can go over this discovery, the video discovery and the photograph discovery with Mr. Robbins before deciding how to proceed.
Mr. Rowland?
No objection.
All right, given the nature of the charges in this case, I think it's a reasonable request by defense counsel. Mr. Dick, how much of an adjournment do you want in order to be able to do that?
I would ask for 30 days, Your Honor.
Mr. Robbins, were you able to hear all of that?
Yes.
All right, do you have any questions about how we're going to proceed with your case?
No.
Are you under sentence there in Roscommon, or do you know how long you're going to be lodged there?
I don't have any idea yet. I'm not sentenced.
Okay, do you know, Mr. Dick?
So I believe he's awaiting sentencing on a probation violation. So, and he's being held on this matter and one other matter as well.
Okay.
So,
All right, so we'll set this for a hearing by Zoom. Mr. Roll, I'll just request that you prepare a writ for Mr. Robbins' appearance for
And
Roscommon.
he believes he'll be in the Roscommon County Jail still for that time. Fine, Judge, I'll take care of it. Make notes in the file. Thank you.
Okay. All right, thank you. That's all for today. Will you be in touch with Mr. Robbins?
yes.
Mr. Robbins, your attorney will be in touch with you prior to that next hearing, and we're going to disconnect at this time.
Thank you.
Okay.
That concludes